All right, good afternoon. This is our endorsement interview, Veterans and Politics endorsement interview for District Court Judge, Department 2. With us this afternoon, we have Judge Richard Scotti. And first off, Judge, we want to thank you very much for taking time out of your Saturday to come talk to us.
Thank you.
Be a part
it's an
of
honor
the
to be here. I appreciate it. Thank you.
And just in the interest of full disclosure, I've known Judge Scotti for a number of years. So just so the viewers and listeners do know that I do know Judge Scotti. So Judge, good afternoon. Can you go ahead and please do a 2-minute introduction of just who you are, some background about yourself?
Thank you very much. I would like to do that. So again, I'm Richard Scotti. I'm your District Court Judge in Department 2. I have served in that position for 6 years, and with the community support, I would very much appreciate having the opportunity to do that again. I am married 30 years. I have 2 grown children. I've been practicing law for 30 years, helping the people in Nevada, in Clark County. Again, I've been on the bench for 6 years. I've been a Board of Governor representative for 2 terms. I've received the endorsement of nearly 100 law enforcement organizations in the state of Nevada. My peers, and this is something I'm most proud of, my peers have bestowed upon me the official preeminent rating, which is the rating signifying that I have the highest ability in legal knowledge and ethical standards. Some of the other things that I have done include serving as the chairman of the Civility Committee, and as part of that responsibility, I helped develop the oath that new lawyers must take upon being admitted to the bar so they can demonstrate their professionalism to the community. I've served as the president of the State Bar Fee Dispute Committee, helping lawyers and clients resolve their monetary issues. I'm also very proud of being a member of the Supreme Court Foreclosure Mediation Program, where I helped homeowners stay in their homes when they had disputes with the bank in those instances where the law allowed them to do that. What I'm most proud of, though, is being a military family, or having been raised in a military family. Since this is a veteran's endorsement that I'm seeking here, I'd like to just take a few moments to talk about my connection to the military. My grandfather, he was an engineer in the Army Corps of Engineers. Then my dad, he was a Marine, a combat Marine who did 2 tours in Vietnam. He volunteered. He wasn't drafted. He was severely injured in Vietnam, and he received the Purple Heart. I was always very proud of him for that. Unfortunately, he was contaminated, and he went through a long, debilitating injury, and he ultimately died about 2 years ago as a result of his injuries, suffered from the contamination, including leukemia and dementia. It's very, very hard for me to accept. My brother was a Marine. In fact, he still considers himself to be a Marine. And I have a sister, stepsister, who is presently a captain in the Marines. She works for an organization or a branch called DevGru. They're affiliated with weapon systems for SEAL teams. She is the director of the DevGru program in Virginia Beach. I have a lot of connection to the military and people that have served in the military. The people of Clark County deserve to have a judge that understands the important issues of the veterans. If I am elected to serve, I will do my utmost to recognize the contribution that the veterans have provided to our society, and I'll do my utmost to make sure they get proper consideration in the courts.
Thank you very much, Judge. The first question I have for you is, as you know, unfortunately, turnout for judicial races typically is pretty low. One of the reasons why I think that is is because, honestly, when you say you're a district court judge, Department 2, people don't really know what's the specific role of a district court judge, and how do you decide, how did they come up with the different departments? And just can you briefly explain that?
Absolutely, thank you. It's a good question. The legislature of Nevada has actually determined the number of departments, and they've allocated a certain number of departments that are all civil, and then a certain number of departments that are a mix of civil and criminal, and then of course we have the family law department. When a case is filed, it is randomly assigned to a particular judge. Then the judge has sole responsibility for the administration of that case. At the present time, I'm handling primarily civil matters, but the chief judge appointed me to serve as the appellate court for all misdemeanor appeals here in Clark County. So I'm proud that I received the confidence of the chief judge to do that. Also, one of my responsibilities is to serve as the appellate court for all eviction appeals. So that is also something that the chief judge has honored me with. Once a case is assigned to a district court judge, the management is the responsibility of the judge. And there's certain parameters about how fast we have to move cases. And of course, there are reporting requirements. The Supreme Court has mandated that we can only take matters under advisement for 45 days, and then we get on a naughty list. We have to resolve cases within 3 years, or we got on a naughty list. If it's 4 years or 5 years, it just gets incrementally worse. So we have a lot of pressure. Even the judges have bosses. That's basically how the caseload system works. We all have approximately 900 active cases at any given time. Now, I don't have to touch all of those cases every week or every month, but at some time during the year, I have to touch them. Most judges conduct trials, well, not full-time, because we have 2 days where we have law in motion, and the rest of the time we try to conduct trials. One of the hardest things about being a judge, aside from having the wisdom and the courage to do the right thing, is chaperoning the attorneys to try to fit everything in so that we can get the maximum usage of all the time that we have for the litigants that need to have a matter tried.
Thank you, Judge. Now I'll pass it on to my colleague.
Thank you.
Judge Scotti, thanks for being here.
Thank you. It is an honor to be here, and I'm glad you're giving us this opportunity.
Oh, thank you. John Moore, former Nevada Assemblyman. Can you tell me where you stand on mandatory sentencing guidelines? Do you try and use common sense, I should say, if for lack of a better term, when you're forced to sentence a person?
Absolutely use common sense. When I was handling felony criminal matters, we would receive parameters for the sentence that we could apply. We had, category E felonies, D felonies, C, B, and A. And depending on the category of the felony, that would determine the range of sentence that we had discretion to commit. For instance, an E felony, 1 to 4 years. We had to sentence an individual to 1 to 4 years. Right? Now, we could put someone on probation. That's a great tool that we've had. We can put someone on probation for 2, 3, 4, 5 years and apply conditions to that to seek counseling, family counseling, educational counseling, anger management counseling, alcohol awareness, impose restrictions. You're not supposed to go on the strip. You can't have weapons, including knives or guns. You can't associate with known felons. We have those tools in addition to the amount of incarceration that we can impose. So I think it's wise to give the judges some parameters, but we need to have the discretion to fit the person in within those parameters, because we have to look the person in the eye. We have to get a sense. Do they really have remorse? Are they going to do this again? Do they care about the community? Are they willing to accept the conditions of probation that we're going to give them? a lot of intangibles there. It's a very hard job when you have to serve as a social worker in addition to representing the community. Yes.
Good afternoon, Your Honor. My name's Gianno Amato, and my question is, if a prosecutor or a police officer were to hide exculpatory evidence and does not turn it over in a case, what would you do? How would you handle that?
Right.
If it was a jury trial?
Prosecutor, well, first of all, that is a Brady violation. It's a violation of the responsibility of the prosecutor to turn over relevant evidence, and there could be serious consequences. It could lead to an appeal if the judge is not proactive in solving the problem initially. So one of the things that I was actively doing when I was handling criminal felonies is I would bring the parties in and have periodic status conferences to make sure that everything is being produced. You have the ability to continue a trial. The defense generally doesn't want you to do that, but sometimes if you can continue a trial and provide an opportunity, a further opportunity for the defendant to obtain that information, that's one way of solving the problem. You have authority as a judge to issue contempt sanctions against a lawyer that violates a law, and that would even apply to district attorneys and assistant district attorneys. I fortunately have never had to hold a district attorney in contempt of court. That's one of the tools that we have. Also, as a judge, you hold a certain level of respect when you tell somebody by order to turn something over. You're generally going to receive that cooperation. There are other tools. You can allow a representative of the defense team to go and review the entire file. And that, in fact, that's typically done. Typically, the defendant and the prosecuting attorney can work that out amongst themselves.
Okay, and if let's say a detective or a police officer, or even a prosecutor, like I asked earlier, were to not turn over evidence and you were in the middle of a trial, how would you handle that? How would you personally handle it?
Depends on the significance of the piece of evidence. That could result in a mistrial. It depends on the significance of the piece of evidence that we find in the middle of a trial. If we find that there was wrongdoing, misfeasance, misconduct by the prosecutor, and it's a significant piece of evidence, then we can declare a mistrial. Another way is imposing an evidentiary sanction, such as a rebuttable presumption that a certain fact is deemed to be true. You can impose upon the jury a finding that a certain fact is proven and not be rebuttable. You can allow the jury to have and to reach a permissible inference that certain facts might be true. So what you have to do is, if evidence has been excluded, the judge has to even the playing field. The judge has to make sure that the defendant has not been prejudiced by that withholding of the evidence. Again, one of the tools is mistrial. Another tool is evidentiary sanctions. Another tool is contempt of court for violation of a court order. Nothing else comes to mind right now. I'm sure there are some other tools. Oh, of course, if there's ever a very egregious violation of an ethical responsibility in your presence, you can report that to the state bar. That's another tool as well.
Judge, I've followed your time on the bench, I won't say really closely, but I've always kept myself abreast of decisions that you've made and that sort of thing. Without going into particulars of a particular case, can you tell us a time on the bench that you've had to make a decision that was really something that you had to soul search, or a very difficult decision for you? Not without getting into particulars, of course.
Thank you. Well, that is a very, very good question, because one comes to mind. It was a situation, and I don't mind mentioning it because it's resolved. It's a case where there was the October 1 shooting. Scores of people killed, right? one of the individuals killed was an officer, Hartfield, right? And he was killed, and there was a coroner report that was prepared, and the Review Journal fought for that coroner report. The wife didn't want it released. I had the wife in my courtroom begging me not to release that coroner report to the Review Journal and the Associated Press and the New York Times. All of these organizations were standing up for the release of that report. There were victims in my courtroom crying, "Don't release it." Our friends and family and the victims and Hartfield, my children don't want to go through this again. The people don't need to see how the officer died, where the bullet entered, how much blood was spilled, where he fell, how long he suffered, what organs were destroyed. People didn't need to see that. Now, being a judge, you can get emotional, but you're not supposed to rule on emotion, and I didn't rule on emotion there. I was emotional on the bench, and I took a recess, and I went back to chambers, and I looked at the law, and I studied the law very carefully, and I reached the decision that the so-called clawback provision under the law applied, which meant that the press had to return it. Now, I'm a strong believer in the First Amendment. I respect the First Amendment immensely. I carry the Constitution in my pocket because that's one of the amendments. It's the very First Amendment that I honor. Sometimes you have to balance the First Amendment with the right to privacy. In this particular case, I didn't think that it was proper under the law for that coroner report to be released. Now, officers were in my courtroom feeling the same way. I made my ruling that it had to be returned. The Supreme Court disagreed with me. But you know what? I have respect for that system. The Supreme Court, they had time to look at it more carefully. They studied the law and public policy and legislative history, looked at what other authorities have done with this type of issue, put it into historical context. They reached a different decision than I did. And I respect that. That's the American way. So I'm proud of my ability to rule in that case. I had the courage, I think, to do the right thing. I ruled based on the law and not emotion. That's the type of case that hopefully doesn't come along too often, because it's very very burdensome on the judge. And you need judges that are willing to put in the time and effort, have the courage and wisdom to do the right thing. And that's why I hope the community of Clark County will give me that opportunity to keep doing that and improve every day.
Well, thank you very much, Judge. That's the perfect ending to an answer that will go straight into my next question. So there's been a lot of debate over the years, and as somebody who is, as you know, has been involved in politics at some level for quite some time now, I do realize that there's politics in everything, right? However, there's a huge debate now whether judges should be voted on, whether they should be appointed, or there's also the Missouri Compromise, I believe is what it is, where the judge is appointed and then he has to be elected to be retained. Out of those three, where do you come down? What do you personally think? I'm pretty sure it's voting right now, but I don't. Yeah, no, you're fine.
All right. So I need to preface my answer with this. As a judge, I am very limited in what I can say. We are not allowed to take a position on matters of public policy that could come before us, or legislative issues. We cannot comment on matters that are pending before the legislature, or are likely to come before the legislature, or likely to come before us. So it's very difficult for me to give you an opinion on that in public. If this were one-on-one, I could talk to you about it. Of course, I'm in favor now of the election system. But even if this weren't an election system presently, and I wasn't going through the election, I would still be in favor of the election system, because that system forces the judges to get out and meet the people. We have to go to events that cover the entire region of the county. We have to go to events that cover different cultural groups, different ethnic groups, different groups pertaining to different sexes, different economic groups, various homeowners associations. We're forced to go to these places, but I enjoy going to these places. It gives us a great opportunity to talk one-on-one. And every time you talk to a voter, they get to know how the justice system works. They get to know the people that are running. They get to hear from us. We get to tell them, what do we do? People need to know what we do. Unfortunately, with the coronavirus, it has really hampered our ability to do that. And so now I am worried about the people understanding what we do and learning more about the candidates. This is a forum that perhaps gives people an opportunity to learn about a little bit more about the judges, because we don't want people deciding how to vote based upon the signs. Whose sign looks the prettiest? Who's got the most sign? We can't have people ruling on that. So I do prefer the election system. I do believe it's important and incumbent upon the judges to get out there and demonstrate who they are, what they do, and why they're most qualified. Now, that's hypothetical. That's my situation. I'm not ruling. I'm not taking a position on what the legislature is going to do. I'm not taking a position on what they should do. I'm not taking a position on which system would be more effective. I'm giving you my personal view in my personal situation, what I want to happen, and how that particular system forces me to get out there and meet the people.
Judge, I'm not sure if you can comment on this or not, because it is kind of a current event right now, and it very well could be brought before you in court, possibly. But I'll ask anyway. Do you see, given the current situation with this coronavirus, do you see that the Governor Sisolak has acted within his constitutional authority, or he is, I don't want to use the word hiding, but using NRS 414 as a way to sidestep the Nevada Constitution to implement the what he's done?
You're absolutely right. I can't comment on that one. I can tell you that at this point I do have a lot of respect for our governor. He's going through a very difficult time. He's going through a very unique situation. I think we have to wait and see. We have to wait and see how this turns out. And then we can comment on the effectiveness of the approaches that have been taken.
Okay, Your Honor. My next question is, so usually in a criminal court here in Clark County, if a defendant is facing jail time, you appoint them an attorney if they cannot afford one. Do you think the same do you think that family court judges should do the same in family matters?
So I don't handle family matters, but I could maybe turn your question over a little bit to general civil matters. I think the analysis would be the same. In my role as the appellate court for eviction matters and as well for misdemeanor appeals, I handle all those, as I said. I often see defendants that show up without counsel. They don't have the ability to pay for counsel. They don't have the ability to order the transcripts that I need to see if the lower court erred. Sometimes they're not sophisticated enough to know how to hire counsel or whether their counsel is even knowledgeable enough to handle the particular area of the law. It is a problem. I have a lot of pro pers coming before me in those situations. We need to look very hard on whether this current system is denying proper access to justice, because justice should not depend upon your economic status or your financial status. This is something that our legislature needs to look at. They'll have debates. They'll look at the law that exists now. They'll do all the things that our legislature does, and they'll make a decision. Whatever that decision is, I'm going to follow it. I hope, though, that we can have a system that allows people to be heard based on the merits rather than external factors.
Okay, and I guess my next question would be, since it's a civil matter in family courts, if an attorney, do you know if they're allowed to give free attorneys in civil matters?
Yes, and yes. In general civil matters, the Nevada Legal Services, Legal Aid, there's Pro Bono Project, there's the Senior Law Project. Each of those organizations have individuals that will work for free. So a litigant in a civil matter can go to one of those organizations and go through the vetting process, and under appropriate circumstances they can have an attorney appointed for them, and I allow those attorneys to appear on behalf of the litigants in my court. I believe most judges would do that.
Okay, well, I guess if a judge were to, are judges allowed to appoint in civil matters attorneys? I guess that's my question.
I'm not allowed to do that in my court.
Okay, so I guess, and you're dealing with civil matters now?
See,
Is that right?
I don't have the authority to require a lawyer to represent an individual in a civil matter that comes before me. I can recommend, I can't force it, I can't order it. I can suggest that the individual who is unrepresented to go down to the self-help center and get more information on how to locate an attorney. I can ask other attorneys that are in the courtroom. I can refer the individual to one of those other agencies that identified. I don't personally have the authority to use funding from the budget to appoint an attorney to represent a civil litigant under the circumstances you indicated.
Okay, now if there was a family court judge here in Las Vegas.
Now, family court, again, I'm talking from general civil. I'm not a family court judge, which might be different.
No, different. So basically it's still civil no matter what. Civil court is civil court. But I guess if a family court judge appointed one litigant an attorney to take away somebody's rights, and they didn't appoint the other litigant an attorney, how would you feel about that? Would you think that that's prejudice? Would you think that's biased? And if you were the chief judge, how would you go about? Would you automatically recuse that judge from that case, or what would you do?
I suppose it would depend on the circumstances. It would depend on whether the second client, the second litigant, is entitled to appointment of counsel. They could be in completely different economic situations. I don't know if even the issues before the court and the respective positions of the parties in family court might make a difference. I don't know if the law would be different on who is entitled to counsel and who's not entitled to appointment of counsel. Family law, I'm not sure. But as a general proposition, it's certainly unfair on the surface to have a judge appoint counsel for one side and not the other side, all things being equal. If that happens, perhaps that means there's some favoritism by the judge. Perhaps that means the judge is not applying the law correctly. In those situations, the litigants have recourse. They can go to the chief judge. They can ask the chief judge for recourse. They could indicate that there's bias or prejudice. They could ask that the judge step down from that case, the case be reassigned. If we're at the stage where there's been no motion, no trial setting, trial has not begun, those situations, at least in a non-family court context in front of me, then the litigants have the right to do what's called a peremptory challenge. Everybody gets one peremptory challenge in a civil case, which means you can ask the judge politely by writing, if you pay your fee, $500, ask the judge to recuse himself. It's automatic, and then another judge is randomly assigned. So that's another tool if you do it early enough in the case.
Okay, and then my follow-up question would be, if you were the chief judge, and I guess you seen that a judge was well, you know what? Better yet, if have you ever seen a judge get recused or disqualified from a case, as long as you have been a district court judge here in Las Vegas?
You know, judges can voluntarily recuse themselves. It happens all the time. Judges voluntarily recuse themselves because they know litigants on the other side, because they know witnesses on the other side, because they're familiar with the issue. For instance, I live in a particular community, and I go to the restaurant in the community, and there was an incident that happened at the restaurant. I didn't see it. It was some time earlier, but I heard gossip about it. It might have been hearsay, but I still heard it. I developed certain thoughts and feelings and subjective views on what had happened based upon that hearsay. In that situation, I had to recuse myself. There's been other political reasons why I had to recuse myself. I might see someone coming before me that I've seen in a political context. Recuse myself there. In terms of disqualification, you're talking about an involuntary disqualification of a judge on a matter. It happens. That's rare. Nothing particular comes to mind right now.
Okay, so basically, I guess I should have clarified the question. Have you ever seen the chief judge ever disqualify or recuse a judge in any manner the whole time that you've been a Clark County District Court judge?
I haven't, but I can tell you I've had litigants ask the chief judge to disqualify me, and it generally comes up in the pro per cases where those unrepresented litigants don't understand the procedure. They think they can disqualify the judge and start over if they get a result that they don't receive. So that's a particular instance that comes to mind, but I've never been disqualified. I've voluntarily removed myself in some instances to avoid the appearance of impropriety.
Okay, so it's never happened. Thank you.
Well, never happened to me. I'm sure it happens, but nothing that I'm familiar with. Possibly.
All right, Judge Scotti, this is a pretty easy question. So it's a two-part question, so you get a little extra time to answer it.
Okay.
Number one, why did you decide to become a judge? I mean, from my understanding, and I could be wrong, from going from your law practice, which I believe you were a managing partner for, correct?
I was a fairly upper-level partner.
Right. Okay. From going from that to judge, there's quite a bit of difference in compensation. So why did you want to be a judge? And the second part of that is, what's your favorite part about being a judge?
Thank you. My sole agenda in running to become a judge was to work tirelessly for the community, tirelessly for the people of Nevada. When I come to work each day, I look up at that building, the Regional Justice Center building, and I say to myself, help me to be the hardest working judge in that building. Help me to listen carefully to what the litigants have to say. Help me to have the wisdom to do the right thing. Help me to have the courage to do the right thing. Help me to be attentive. Help me to make sure that the people that come before me, that the people in the community know that they're going to get a fair shake. That's why I wanted to run, because I believe I can do that. I have done it. I'm going to continue to work hard to do it. That's been my agenda from the first day I decided to run. Every day of my career, I do that. I'm going to continue to do that if I'm reelected. That was my agenda, and that's what I hope to continue to accomplish. The last part of your question, what's the most rewarding part? Again, I have to go back to pro persed in front of me. I've had several come in front of me, and they are scared. They don't understand the system. They've been in front of a lower court judge. They perhaps had a ruling that went against them, and it was an abbreviated proceeding. They didn't have an opportunity to be heard, or they felt like that. On at least 2 occasions, they've come before me on an appeal. And they lost, but I spent a lot of time listening to them. I asked questions. I looked at their documents. When they leave, they say, Judge Scotti, I may not have won, and I may not agree with you, but you listened. You gave me a fair shake. I acted, I believe you cared. That's the most rewarding part of the job, is to hear that you're a judge who cares. And I appreciate that, and I hope I can continue doing that.
Your Honor, my next question is, with domestic violence, have you ever personally had to lock up a domestic violence victim to be able to get inculpatory evidence?
Let me think. I've certainly had occasion to direct defendants to jail or incarceration as a result of domestic violence. Your question is more specific to obtain inculpatory evidence.
Well, I guess it's more towards a domestic violence victim.
I'm thinking hard to see if that's ever come in front of me. I don't think that's ever come in front of me. Do you want to give me a hypothetical on how I would handle a particular situation? And I'm not sure if I could answer a hypothetical, but we could try.
Okay, well, I guess if...
And I'm sorry, maybe I'm not understanding the question.
Okay, I guess if let's say there was a supposed victim of domestic violence, and they weren't, you know, like let's say they weren't getting up and testifying, and they were to miss trials, would you ever lock up a domestic violence victim? And if you would, how long would you lock them up to be able to force them to testify?
So you're assuming then that the domestic violence victim has been subpoenaed to appear and
Yes.
And has not appeared, and it's a violation of the subpoena.
Yes.
I know that happens. I have signed subpoenas to require material witnesses to be brought to court, and it has happened on occasion, and I have required that. Do I like to do that? No, because I don't want actually material witnesses, not the victim. I haven't required it of the victim. That situation has not come before me, but the material witnesses in situations where they're not completely innocent individuals, at least allegedly and on the surface, and they have material information, and that information will shed light on the case and help the judge to reach justice, to make sure we make the right decision. Yes, you can issue a subpoena. They're brought in a very polite and respectful manner to court, and they'll have an opportunity to be heard, and then the subpoena is quashed. It does happen. It should be done very sparingly, though. It's a system that is in a place, and I believe the judge has an obligation to do that under the law, to bring a material witness forward.
Okay, but instead of I guess not a material witness, let's say it was a victim of domestic violence or a supposed victim of domestic violence. Have you ever seen an incident where a domestic violence victim were to be locked up, and how long would be too long that a victim of domestic violence should be locked up?
Well, first of all,
to gain testimony.
First of all, a defendant under the Constitution is entitled to confront his or her accusers. So, if the charges are going to remain, then the defendant is entitled to have the victim there. The victim is the piece of evidence that the district attorney is relying upon against the defendant. So, yes, there might be some exceptions. How long would the person be locked up? Well, until the time for the testimony, until the need for the testimony has evaporated. It's the only way to give a defendant a fair trial. It's what our Constitution requires. So yes, I would very unfortunately have to remind the individuals of their responsibility to comply with our constitutional system, the best system in the world. Remind them that they have an obligation to come forward and to allow themselves to be examined.
Okay, so basically the incarceration of a domestic violence victim could be indefinite.
No, it'd be until the trial is over.
So,
right?
so if the trial took a couple years.
And then, well, it may be a mistrial. I'm thinking this through. I've never had that situation come up. I mean, you have a right to confront your accusers. If that person never comes forward, I suppose the district attorney might have to drop the charges. And I'm not sure about this because the last 2.5 years I've been handling all civil matters. I have to be honest with you, with the exception of the misdemeanor appeals. So that would be a felony trial issue that wouldn't come in front of me.
Okay,
so,
thank you.
Yeah. Oh, one more thing. In the civil context, if a person violates a court order, that is civil contempt of court. Now, the rules of civil contempt of court under Endorsed Chapter 22 allow the judge to lock a person up until that person complies with the court order if that court order is capable of being complied with. Usually that comes up with situations where the individual has failed to turn over documents. It's a little bit different context. I'd have to refamiliarize myself with the criminal laws that I studied 2.5 years ago to answer your question more thoroughly. Thank you.
Okay, thank you, Judge Scotti. At this time, that concludes the questions we have for you. Can you do me a favor, and can you just look in the camera and please tell the voters why they should vote for you and also a way they can get in contact with your campaign?
Very well. Well, let's tell the contact information first so I don't forget it. So, again, it's Judge Richard Scotti, Department 2. My website is www.reelectjudgescotti.com. That's the best way to reach me. So I can sum up why the voters should vote for me, why I would want them to vote for me. The community is entitled to a judge who cares. They're entitled to a judge who listens. They're entitled to a judge, as I said earlier, who has wisdom and courage. The judge who is going to work tirelessly. They are entitled to a judge who is going to give it his all. A judge who promises himself when he goes into the courtroom every day that he's going to do each of these things. A judge who gives respect to veterans. A judge who understands that when veterans decide to go off to war, they go to their wives or husbands, and they tell their wives or husbands, I may not come back. You may have to raise our children. And fortunately, most of them do come back. When they come back, they're entitled to a piece of this country. They're entitled to our respect. They're equity owners of our country. We have to do something more for them. The people of Clark County need a judge who understands the issues of veterans. You elect me, I will understand all these issues. I'll do all these things. I guarantee you that you will not see a judge that has let you down. So please re-elect Judge Scotti.